Good afternoon and welcome to today's webinar hosted by the National Network of Credit and Financial Professionals. I am here today with Joe Coleman of Kane, Russell, Coleman, and Logan PC, and John Everhart with Nikon Americas Incorporated. A few items to get out of the way before we begin. If you have any questions during the course of the presentation, you can ask them through the questions function on your side panel. We will gather all these questions and save them for a Q&A at the end of the presentation. If you are looking for a copy of the slides to follow along today, they are available through the handout section in your side panel. We will also be sending a copy through email after the presentation is complete. The last item is that we will have a brief survey that pops up after the webinar ends. It only takes about 30 seconds to fill out, but it gives us a lot of great information on how we can continue to make the webinars better for you. Now, Ken Frisco will give you a brief intro of our speakers.
Thanks, Sharon. Before we get to the actual bios of the speakers, just a quick note on the agenda and what we're going to be listening to today. We're going to be listening to why you should consider consignments and consignments as defined by Article 9 of the Uniform Commercial Code. Also, protecting consignments from third parties and comparisons between consignments and purchase money security interests. Also, benefits of using consignments for both consignors and consignees. Finally, risks to consider as a consignor and how to protect yourself, which is most important. Now, I'd just like to jump to the next slide. I'm not going to read the whole background of all our speakers, but I just wanted to add one more bit of information about Joe Coleman, our speaker. He has represented 40 creditors committees in 16 states. So Joe has extensive experience in creditor rights and bankruptcy. So without further ado, and I will turn the presentation over to John Everhart, who will begin the presentation.
Good afternoon, everyone. Well, thank you for joining us today. And the topic is one that has aspects both from a credit protection risk mitigation standpoint, but also it's a very, very important and very useful tool in the area of supporting your various employers with regard to promoting their products and helping them to grow their business. It's not often thought about by some companies with regard to utilizing it as a way to advance their business while protecting credit, but it really should be, and more companies have been utilizing it. But what's so critical is that it's very, very important that as you're involving your company in such a process, that it is done and done correctly. And if done correctly, it can become a very, very useful tool. So why don't we find out a little bit more about that? And I'm going to turn this over to Joe to get us started. But the definition we know is that sales on consignment are generally described as a transfer of goods from a manufacturer to a merchant in which title to the goods remains with the manufacturer. Very important point. Until the goods are sold by the merchant in the ordinary course of business. Now that's the layman's term. Joe, tell us about the UCC definition.
Good afternoon, everyone. It's a pleasure to be here. The definition under the Uniform Commercial Code of Consignment is at Section 9102 and defines a consignment as a transaction in which a person delivers goods to a merchant for the purpose of sale. And so, first of all, you have to be a merchant. And let's just use as an example, John is with Nikon. Nikon sells inventory to Sam's camera shop. Well, a merchant deals in goods of the kind, or deals of the goods of that kind under a name other than the name of the person making delivery. In other words, number one, Nikon is selling to Sam's. Nikon is not selling to another Nikon entity. The merchant's not an auctioneer, and a merchant is not generally known for selling consigned goods, such as a consignment store. The delivery from Nikon to Sam's has to be more than $1,000 under the UCC, and the goods were not consumer goods immediately before the delivery. Again, not a consignment store type of transaction. And Nikon is not intending to sell the goods on a security interest basis. Rather, Nikon is intending to sell the goods or transfer the goods on a consignment basis. So that's our technical definition. But essentially what happens is Nikon delivers goods to Sam's Camera Shop, and at Sam's Camera Shop warehouse, there's a bunch of Nikon goods. But Nikon owns those goods, retains title to those goods in the possession of Sam's Camera Shop. That is a consignment. Now, given in our example, Nikon has their property, title to their goods in someone else's possession, we want to protect our goods. And there's a lot of reasons that we'll get into, advantages for doing a consignment, but one disadvantage is you've got your goods at somebody else's warehouse. So we want to protect it by some kind of notice. And we want to put the world on notice in some way, shape, or form. For example, if Sam's Camera Shop has a default on their bank loan, and the bank's got a lien on inventory, the bank doesn't know that Nikon and Sam's Camera Shop have a consignment agreement. The bank's moving in and foreclosing. Or landlord, they have statutory landlord liens. Or if Sam's files bankruptcy, then we have a whole bunch of different folks who may claim an interest in inventory. So notice to the world that Nikon and Sam's Camera Shop have entered into a consignment agreement is a very important aspect of protecting your consignment interest. There's 3 methods of giving this notice. You can put up a sign. Please don't do that. You can prove in court, if you have to subsequently, that Sam's Camera Shop is known to the general public as being someone who sells consigned goods. And please don't do that either. That's similar to, actually, the Family Christian Bookstore filed bankruptcy, and they were able to prove that up as an example, but it's very high risk. Number 3, we want to notify the world by filing a financing statement, a UCC-1. That's not only the safest alternative, but it's absolutely positively the only one I recommend. So continuing protecting our consignments from third parties, the Uniform Commercial Code expressly provides how we give notice to protect ourselves. Article 9 specifically provides that for consignment filing, you can file a UCC-1 without creating a presumption or confusing people about whether it's a security interest or not. You are expressly authorized and encouraged to file a UCC-1. And that lasts for 5 years. So the biggest problem with consignment sales that I've seen over my career is people do not follow the Uniform Commercial Code. I think it was in Sports Authority, for example, over $85 million of inventory on consignment, over 170 different consignors of inventory. Extraordinarily few properly protected their consignment interest. And so that's a big problem. And part of what we're going to talk to you about today is how do you do it right? How do you protect your interest? Because once you do consignments correctly, then there's a lot of creative and both in trouble situations and, frankly, a lot of non-distressed situations in which you can gain market share and do other things to support your company. So the number one problem with consignment sales is failing to jump through the hoops expressly laid out to UCC, and again, it all comes primarily down to notice. The UCC establishes rules, so we know we can get our consigned goods away from the bank who has a lien on inventory. We know, and for example, Nikon delivers its $100,000 of Nikon inventory. It's in a warehouse of Sam's camera shops. Well, Sam's going out to get a bank loan, and the bank comes to Sam's warehouse, looks at the inventory, and they decide to make a loan secured by inventory. Well, Sam's bank has a right to know which inventory is owned by Sam and which inventory is owned by somebody other than Sam, because they're making a loan on that. So the goal of the UCC is to put the world on notice and prevent these secret liens or these liens that are not properly perfected or doesn't put the world on notice. The Uniform Commercial Code, I'm sure some of you are familiar with purchase money security interests. But the Uniform Commercial Code says, for purposes of perfecting your consignment interest, of protecting and making sure third parties, banks, secured lenders, trustees, purchasers, if someone wants to buy Sam's camera shop, and if there's not a proper notice, not a proper UCC1, how does that purchaser know that he can't buy the Nikon goods? So the UCC says, for consignment, we're going to follow the perfection scheme for purchase money security interests. So a consignor is a consignor is considered to hold a purchase money security interest in the consigned goods, and notwithstanding that, the consignor retains ownership or title to the goods. So we have a couple different concepts here. A consignment is different than a purchase money, because of purchase money, you sell the goods and take back a security interest. Consignment, you physically put the goods in Sam's camera shop warehouse, but you retain title as opposed to security interest. With that difference in mind, now how do we notify third parties? The bank, the trustee, the creditors committee, the landlord. We do that by following the purchase money security interest perfection. So let's look at that a little bit more and clarify it. So a consignment. Nikon sells goods on consignment and delivers to Sam's camera shop. Nikon owns those goods in the physical possession of Sam's. In comparison, a purchase money security interest, Nikon sells the goods to Sam's camera shop subject to taking back a purchase money security interest. The difference here is the delivered goods under purchase money, they're owned by Sam's. Sam has title. Sam owns it. Nikon has a security interest and has potentially the right to foreclose, but they're not Nikon's goods. On a consignment, to the left of the screen, the green, when Nikon sells to Sam's camera shops, on a consignment basis, Nikon owns the goods in the possession of Sam's camera shops. That's one big difference. The ownership between the two. Now, the point I want to make is, how do we protect our interests in consigned goods? It is exactly the same way that a purchase money protects their interests. You protect your interests by, number one, giving a notification letter to the existing secured parties who show up in a UCC search, filing a UCC1 saying you have these goods on consignment. Nikon's goods in possession of Sam's Camera Shop are sold on consignment or delivered on consignment. And you have to do that all before you make your delivery. So consignment's different than a purchase money. And the difference is who owns the goods. But as to third parties, how you perfect, but third parties will notice, consignment and purchase money is the same. The proper filing of a consignment under PMSI rules perfects consignment's interest in the goods and puts everybody on notice and prevents these secret liens. It prevents a bank from complaining, I did my due diligence, I saw all these Nikon inventory, I didn't know Nikon still owed it. It puts everything on top of the table because everyone can see the UCC ones. So given we protect our consignment interest through the PMSI rules, let's just quickly go through the PMSI rules. Now, PMSI allows a supplier to obtain a security interest with priority over pre-existing bank or other liens. And you think about this, it's a great thing. You can sell on a PMSI basis, and even though the bank has a pre-existing lien, and you file your UCC1 after the bank, you still win. And you know, spending a lot of time representing vendors, I love this rule. I love the fact there's a methodology and a legal strategy to enable the vendors to beat the bank. So a purchase money, the supplier sells the goods, doesn't deliver physical possession, and retains a lien like consignment. You sell the goods, you take back the purchase money, and you get a lien on those goods that you've delivered, or a security interest. And again, it's not unfair. You know, banks could be grumbling about this, saying, hey, I had my first lien on all inventory. You delivered inventory after the fact. I should have a lien on it. Well, the truth is, in our example, Nikon wouldn't have sold the inventory to Sam's Camera Shop unless they got a purchase money. So the bank never would have got a lien on that, or at least that's what the law says. That's the rationale. What is the procedure to obtain a purchase money security interest? And again, we're talking about this because the PMSI, the purchase money steps, are how you protect your consignment. So number one, you get a security agreement from your customer, have them sign it that says, I grant you a purchase money security interest. Number two, you determine where is your customer located. And location under the UCC is almost always a state of incorporation. So now Sam's Camera Shops, they're incorporated in Virginia. I go to Virginia's Secretary of State. I do a UCC search. I see a bank, a landlord, some equipment vendors have filed UCCs. So the next bullet point, I provide a written notice and just tell the existing secured creditors that show up in my UCC, Nikon is selling goods on a purchase money security interest basis. Be advised that we're going to sell these goods and we have a purchase money lien. So they're notified. And then we file a UCC1 before we deliver any of the goods. I always advise, after you do this, do a follow-up UCC search. Make sure your UCC, your purchase money, shows up. Why? Well, if by accident someone put on the UCCs Sam's Camera Salon instead of Sam's Camera Shop, that UCC isn't going to show up. It's defective. You lose. Your lien is not properly perfected. So by doing a UCC search after, to make sure you properly filed a UCC1, is a really important preventative step. Then I tickle my calendar for 4.5 years to make sure I file my UCC continuation statement to keep my lien. So that's what we do with the PMSI. And as we've discussed, on a consignment, which is a different transaction than a PMSI, but we use the PMSI rules to protect and perfect our consignment. So look at that. The differences are almost zero. Instead of a security agreement, we obtain a consignment agreement. Instead of prior written notification of a PMSI to existing secured creditors, we provide a written notification of a consignment, a contemplated consignment transaction to existing creditors. But everything else is the same. We do figure out what the debtor's location or the customer's location, conduct the UCC search, provide written notification of Nikon's proposed consignment transaction with Sam's Camera Shops. We file UCC 1 in the name of Sam's Camera Shops in his state of incorporation, not for Sam's Camera Salon, because that won't work. Now, I do want to bring up one issue as far as real life. And in fact, John,
yes,
what do you do when you do these written notifications? So Sam's Camera Shops, they have their bank, Big Burly Bank. And you're going to write a notification letter to Big Burly Bank and say, oh, by the way, I'm selling my goods on consignment. And I imagine that could get Big Burly Bank mad or even cause a default with Sam's Camera Shop. How do you handle that? What are best practices?
Well, Joe, from a best practice always, having transparency between all of the parties, in particular with regard to the secured parties, is absolutely critical. One of the things, as you can see, and as Joe has described this, there is a fair degree of upfront documentation that is needed in order to be able to protect your interests. When doing so, it is absolutely imperative that the secured parties, and it's the reason why you go through these steps, are actually communicating and being clear to each other. One of the things you don't want to find is where the supplier and the customer have entered into an agreement and the secured lender or lendors have not been made aware of what is going on. Number one, you'll defeat the purpose of what you're attempting to do with regard to perfecting your interest. Number two, you may find yourselves placing the customer in default under their prior secured agreements with their primary lenders. As in most things, as in all things, in fact, being upfront, being honest about what the steps you're taking and the reason that you're taking them is so absolutely important. And so we would encourage, right at the front end, explain the reason for the transaction, why it benefits your customer, and we'll get into some of those points in a minute. But be very, very clear, and you're going to need to be clear with your documentation if you want it to remain perfected.
Thanks, John. So really, the bottom line there is, let's say you're using consignment as a method to compete with a competitor, to get a leg up on a competitor. It's not a distress situation. Last thing you want to do is increase your sales with your customer, and then as a result of your consignment transaction and sending a notification letter to your customer's bank, you have caused your customer to get in default, or cause a default with their bank line, or otherwise just hurt the relationship. Well, along those lines, John, why don't you go through some of the benefits that you've experienced and why folks should consider consignments?
Okay, so, you know, oftentimes when we start to talk about securing your exposure through various different means, whether it's through purchase money security interests, letters of credit, guarantees, whatever, we're often thinking at times of situations where we're already facing a high risk and we are looking for risk mitigation. But that's not the only time you should be thinking about certain tools, consignment being one of them. In point of fact, so many consignment arrangements emanate at a time in a relationship with a customer where it is for very, very proactive reasons. Quite often the term consignment is first raised not by anyone concerned from a credit perspective. It is raised from its chance to improve your company's position with the end customer. Very, very important that if these items do get raised, that everyone who's working in that process, be it your senior management, your sales organization, your logistics organization, certainly your either in-house or outside legal advisors, all understand the transaction that's going to be contemplated. But with that in mind, what consignment can do for you and your company is to provide a competitive advantage. There are reasons on both sides of the relationship, both from the supplier standpoint and the customer standpoint, where having consigned goods in their mix of inventory is very, very helpful. First off, on the consignor side, as Joe has already pointed out, and the primary difference between consignment and purchase money security interest is that you retain the title to the goods. That is so very, very important and a great, great strength in the event of any default. So in the event of a default, you may work very, very quickly to obtain control back of those goods. You have a priority over the bank's security interest in the inventory. And it's relatively inexpensive and easy to implement if you go through all of the steps that are necessary. And that includes, as we've discussed, proper filing of the notification, proper filing and of any amendments and extensions to that. Joe, if you want to advance. For the consignee, it also provides some very significant opportunities. First and foremost, it can improve their productivity and efficiency. By not having to wait for the inventory to arrive, having it in ready and available quantities, they can begin drawing down that inventory and keep production ongoing. Think in terms of goods.
Excuse me, John, can I just interrupt you for a second? So
absolutely.
Explain, I've always dealt with consignment as a way to continue doing business with a distressed company, distressed customer. But it seems like you're getting into strategic reasons why your customer, a healthy customer, may want you to sell on a consignment basis. Is that true?
That is absolutely correct. In today's global world, particularly with regard to maximizing supply chain initiatives between supplier and customer, the key importance of being out in front and being flexible in the way that you're able to provide the goods to your customer can be very, very important. Speed matters, and it matters to a very large degree. And in particular, it is an advantage to you as a supplier if your goods are there versus your competitor's goods. So having the material on hand and ready to be drawn down by the customer makes you far more important, far more critical in some cases to their production. And if in fact your goods are part of a sole source part or parts within or raw material within that customer's production, having those goods there constantly and so there's continuous flow eliminates downtime for the customer in their manufacturing processes, improves their turnaround time, improves their own servicing to their customers. It enhances their productivity. It can lower their working capital investment as well. And the reason for that is because of the fact it's consigned goods, and as we've mentioned, the title is retained by the supplier, the customer does not need to report that inventory as debt on their books. So this again assists them, particularly if they have or are actively utilizing their lines of credit for other types of purchases. The payment process changes as well. Now the customer is paying only as he needs those goods, not taking in goods that he may not utilize for some time to come. And this becomes very important if the customer is seasonal in nature as far as their manufacturing is concerned, and the goods might not be able to be brought in even quantities. It could be a situation where your company as a supplier can only provide the goods in lump sums. Having the goods then in a constant consignment role where it can be replenished can be a very, very important competitive advantage. The ability to return the goods. Now the goods, because they have remained titled with the supplier, those goods, if in fact they are no longer necessary and independent with regard to the terms and conditions of the consignment agreement, which we all have to remember is an important component of this that needs to be completed, but that consignment agreement should detail conditions under which goods, unused consigned goods, can be returned to the supplier. All of these, from a very proactive, competitive standpoint, can actually put your company in a much, much stronger position vis-a-vis their relationship with the customer.
You know, John, as you talked about all the advantages of a consignment, it made me think of one more difference between a purchase money and a consignment transaction. If I have a purchase money, so I've sold the goods, I took back a security interest, and there's a default, well, I have to put my customer in default. I have to conduct the Uniform Commercial Code Article 9 foreclosure sales, either public or private. I have to give notice to other secured creditors. I have to make sure my foreclosure sale is commercially reasonable, or I could get, there could be a question about the propriety of my foreclosure sale. To foreclose a security interest, I have to jump through several hoops, and it takes a while, and there's some risks and expense. Under a consignment, if my customer goes in default, they're my goods. Under the consignment agreement, I get to take my goods back. Simpler, easier, less risk, less expense. Okay. So with all those benefits, we need to also make sure we're apprising people of risks to the consignor or the supplier or the Nikon in my example. First of all the steps we talked about, notification letters, purchase UCC 1 filings, all has to be done prior to the consignee's receipt of goods. Again, otherwise the bank or other parties would be misled. I would note that one exception under the preferential transfer rules, because granting a security interest is an example of a preference, if it's within the 90 days. You know, to prevent that whole preference problem, you can actually, as long as you perfect within 20 days of when the goods are delivered, you get out of the preference problem. But I don't want the preference tail to wag the good judgment dog. You must perfect and file UCC 1 and your notification letters before you deliver the goods. And your consignment protection is only good for 5 years, so you have to tickle to make sure you file a continuation statement. And when you do the continuation statement, there'll be new secured creditors coming up in a UCC search. There could be copy companies, lessors of telephone equipment. There could be a new landlord. There could be a variety of things. So you have to go through the notification process again. Risk to consignors continued. If you fail to jump through the hoops that we've outlined, notification letters, UCC 1s in particular, then your consignment sale, as it pertains to third parties, if the bank's foreclosing, if there's a bankruptcy, then your consignment, Nikon's delivery of goods on consignment with a signed consignment agreement with Sam's Camera Shops, is no different than a sale on open account. So you do have to perfect it. And I've seen the Zales bankruptcy, the Circuit City, the Whitehall Jewelry, the Sports Authority. It just seems like a lot of people sell on consignment. And when I get in these bankruptcies, so few have not properly perfected. So I know I'm starting to repeat myself, so I'll stop. But there's a lot of benefits to consignment, but you have to jump through the proper hoops. Another risk, you have goods, your goods, at your customer's warehouse. Well, you have to make sure your sales rep or somebody is monitoring those goods. They're your goods. And John, on a practical level, how would you handle that? Because what recommendations do you have? Because that's a very important responsibility.
Yeah, Joe, there is actually still very, very many things that would need to be considered during this process, and ensuring that you have gone through these steps is absolutely critical. And I would raise the issue too that with regard to not only having the filings done properly, making sure that you have in fact followed the agreements of your consignment agreement. For example, if your consignment agreement stated that you will be actively monitoring the inventory levels, if you have stated that you will be taking specific actions to ensure that the billing process will be done consistently, that the inventory will be taken at a regular schedule, that you will bill your customer at the proper period. If it is found that you are not doing these things, a court can and have in some cases ruled that the relationship was not in fact a true consignment but was in fact a deferred sale. So the recommendation that I have always made to all parties with the companies I have worked with and to colleagues that have been involved in this process is make sure that if you are going down the path of a consignment program, that you can and do ensure that the things that you've agreed to can be achieved. This will require, in most cases, the active involvement of not simply your department, but of either your logistics and or your sales function to be involved in this, ensuring that the billings and the reconciliations are being done properly. So,
in my experience, just so everyone goes into this with their eyes wide open, and we've gone through the benefits, but your goods are at your customer's warehouse or retail locations, and they're drawing down or they're taking your goods on an as-needed basis. And once they draw down the goods, that's when they need to notify you. You send an invoice and they need to pay for the goods, subject to whatever credit terms. But if you're not monitoring your goods and ensuring that what your customer says they're taking is in fact what they're taking, and reconciling to make sure you're invoicing for everything as they take it down, then this could really be a mess, and that would be another risk to the consignor. Another risk would be if your customer changes their name. So your UCC, you've got a finite period of time to amend your UCC, or if there's a merger or some kind of corporate restructuring or consolidation, you need to make sure in those situations that in fact your documentation is all updated, or else, a year later they file bankruptcy, you're unperfected. So your consignment becomes simply a sale and open account. And you do need to make sure the goods that are subject to your consignment are conspicuous, and you can tell Nikon's goods, in our example, from somebody else's goods, or else if you want to reclaim them, how are you going to do that? Or if a bank is trying to see exactly what they're lending on, if it's all confusing, you have to take some steps to make sure it's readily identifiable. Continue with the risks. Again, we talked about you have to send a notification letter. We sure don't want to cause a default with the bank. I think John's suggestions were very good. Let's be upfront. Make sure your customers talking with their banks, there's no surprises. As I've emphasized, your consignment is only applicable and only protected on future shipments after the notification letters in the UCC. And here's one thing I always like to point out, different than a bank financing on inventory, your consignment interest is only in the goods in debtor's possession. If the debtor draws down the goods, you no longer have a consignment interest in those goods because they've, at that juncture, been technically sold to the debtor. And if the debtor sells a bunch of your goods and takes back a receivable, sells them on credit, your customer sells them on credit, your lien doesn't float like a bank's lien from inventory to receivables. You only have a consignment interest in the goods, your goods, in the possession of your customer, and the Uniform Commercial Code says identifiable cash proceeds. My experience is there's never identifiable cash proceeds. It's all commingled. So your consignment interest is only as good as the goods, your goods at your customers that are not yet sold or drawn down by the customer. Let's talk about some bankruptcy considerations. One of my favorite topics. The Uniform Commercial Code makes clear that if Joe Coleman gets a judgment against Sammy's camera shops, and I go get I have a judicial lien, and Nikon has not properly perfected a consignment, I win. If Sam's camera shop files bankruptcy and Nikon hasn't properly perfected a consignment, then all the creditors win, or the bank wins. So once you're in bankruptcy, it's really all about perfection. As I mentioned, it's amazing how often in a lot of bankruptcies, and we're going to see more and more retail, people sell a consignment but don't properly perfect. Has that been your experience, John?
Absolutely. Too often, the transactions, and it's not surprising, a number of these transactions are entered into at a time when companies are in a healthier position. And the monitoring that is necessary and ensuring that it was done properly are really not thought through too often. I shouldn't say too often, often enough. And that, in fact, relationships change with customers. And to that point, one of the things that's so very, very important in all of these steps, no matter what the lifespan of the relationship with the customer, it never takes away the responsibility of the credit professional of continuously knowing the financial health of your customer. Relationships change. Companies who have been in business for many, many years find themselves later on in a very dire situation, as we have seen in retail, most recently with what has just transpired with Toys R Us is a great example. So what might have been entered into years ago will change. It is very, very critical that even if you are perfected correctly, that you understand what your strengths and opportunities are vis-a-vis your agreement. One of the things you may wish to have in your consignment agreement is that it remains within your or the supplier's judgment as to whether or not the creditworthiness of the company continues, and the ability to exit a consignment arrangement at any time is retained by the supplier. So continuous monitoring is absolutely critical, because those things will change, and you want to be prepared. You want to certainly know where your inventory levels are as you approach what could be a difficult period. Unfortunately, a lot of companies don't employ those kinds of monitoring tools.
Hey, thanks, John. Continuing with the bankruptcy considerations, how does a consignment program where you're delivering goods but retaining title, how does that intersect with the 503b9 rights of an unsecured creditor? And what 503b9 and the bankruptcy code means is that if you deliver goods and a debtor receives them within 20 days of filing bankruptcy, you get an administrative claim. An unsecured creditor gets an administrative claim. Well, in a consignment, when are the goods received? Are they received when Nikon physically delivers goods but retains title? Or are they received when Sam's Camera Shops draws down from the Nikon inventory and sells them? So, I mean, when they're received is a big deal as to what, whether you have an administrative claim. And it's interesting, Circuit City, and I don't necessarily agree with this, but nobody asked me, but in the Circuit City bankruptcy, the court said, for purposes of a supplier getting a 503b9 administrative claim in a bankruptcy, the goods are received once the customer debtor has physical possession of the goods. So even though Nikon delivers the goods and retain title, that is when, in the Circuit City decision, that's when the 20-day period begins. Now, looking at a similar issue but in a different context, I'm sure most people on the phone are unfortunately familiar with the legal shakedown known as preferential transfers. One of the big exceptions or defenses under 547C is new value or subsequent new value. So if you receive a preferential transfer but you have subsequently given new value, sold goods on credit, or delivered goods on credit, when have you delivered goods on a consignment arrangement? In other words, when's that transfer of goods? Same issue. Is it when Nikon gives physical possession to Sam's Camera Shop, or is it when Sam's draws down from the Nikon inventory? Because the new value has to be subsequent after the alleged preferential transfer was received. Well, in this case, the court considered the date of the physical shipment, and the court considered the date that the debtor drew down or ticked the inventory, and said the date of the transfer, the subsequent new value, is the date when the debtor customer drew down. So a completely different result than the Circuit City decision in the 503b9 context. John, you may ask me, how do I reconcile them? And I'd say, I really don't have a clue. I don't think they're very reconcilable. Different context, 503b9 versus new value and preference, but it's just kind of interesting how consignment plays out in a bankruptcy.
So, Joe, question for you then. We get the word, the horrible word that all of us on the credit side can't stand. It's the phone call that tells us that either they've engaged counsel or are preparing, or the filing has taken place. What do you do out of the gate?
Okay. Number one, I'm going to ask my client, John, I want to see your consignment agreement. I need to see your UCC notification. I need to see I'll pull your UCC 1. I want to make sure you have a good, properly protected, properly perfected consignment interest. I get those documents together, and I'm running into court on an expedited basis. And I'm going to tell the court and the debtor I have a properly perfected consignment interest. That means the inventory in the debtor's possession is mine. I have title. Therefore, my property, my inventory, is not even property of the estate. Debtor has no rights to it. I want it back. Now, at the very beginning of the case, but consider the strength of that argument. It's not even property of the estate. The purchase money vendor is arguing I'm entitled to adequate protection, which may or may not work. The unsecured supplier is got nothing. Whatever they sold, the debtor's going to do whatever they want. So there's a continuum there of purchase of consignment, stronger argument, better than purchase money. Purchase money, at least you get adequate protection, much better than just unsecured. But the judge at the beginning of a bankruptcy does not want vendors to go and dismantle the debtor on the first few days. So, the debtor is going to say, well, what's it going to take for me to continue selling your goods? And I'm going to say, well, since they're my goods and you really don't have a right to them, at a minimum, I want you to follow the consignment agreement. And there's decisions where the court said exactly that. Do the consignment agreement. And that means I'm getting paid for the goods that were delivered. As the debtor customer sells them, draws them down, they've got to pay me under the consignment agreement. That's a remarkably better result. I'm getting paid for what I delivered pre-petition. The unsecured creditor certainly is not getting paid for what they delivered pre-petition. And again, the PMSI creditor kind of in the middle, they're going to get some adequate protection that may or may not end up being helpful. So I think consignment puts you in a really good position, but only if you have properly perfected your consignment interest by having the notification letter to all secured creditors and by having the UCC 1 filed. Okay. John, I'm going to turn it over to you because I'm starting to run out of time.
All right. Well, we're going to try to wrap this up. So I think you can see that both from a very proactive and market-driven, sales-driven perspective, there are advantages that can be derived from entering into a consignment agreement. We've also seen how they differ from a purchase money security interest. The primary takeaway there, you as the supplier retain title. With regard to your customer, it can be a huge advantage to them, improving their productivity, their efficiency, cash flow. It can reduce their costs. It's a real competitive advantage. However, in addition, as Joe has already pointed out over and over again, filed properly, transparency to the secured lenders that are currently existing, ensuring that you have filed in the right locations, making sure that the names have kept up to date. And by the way, that includes going back and checking to make sure that your inventory stays where you said it was going to stay and wasn't transferred to some other location, that the correct names and addresses are on the contracts that coincide with the business that you're actually conducting and invoicing for, and that you understand your rights in the bankruptcy and insolvency. And this is why you don't want to hesitate for a second. If you're involved in one of these cases, you want to be the first ones on the phone to your counsel, calling to make sure that you're out in front with regard to the court in making clear that your rights actually supersede those of the bank. But one should never think of this solely as a tool to be utilized in risk situations. And like all things, relationships change. You want to stay on top of them to ensure that if in fact the customer's situation is deteriorating from a financial standpoint, you may wish to continue to utilize it as a risk mitigation tool. But as in all things, beware, understand, make sure that the controls that you agree to in your consignment agreement, which has to be executed between the parties for this to be effective as well, are actually being adhered to. But if you do these things, you actually can find that this can give a competitive advantage and add added protection in the event of financial distress.
I think we have a little bit of time for some questions.
Okay, Joe, we have a two-part question here from Derek, and he apologizes if it's been discussed. But the first part of his question is, who signs the consignment or PMSI for an organization?
Okay. Derek, it wasn't discussed, and it's a great question. Generally speaking, you have a security agreement for PMSI. You have a consignment agreement for a consignment. Generally, it's an officer of the company or someone else who is legally delegated that authority by the board or by the officers. So it has to be someone that the company has in fact authorized to bind the company. Now, let's say, Derek, for example, someone signs a consignment agreement that isn't authorized. Well, as it pertains to third parties, they're probably going to be able to, more likely than not, will be able to hold that signatory and that company liable because of an apparent authority situation. As far as the UCC ones, the supplier debtor doesn't have to sign those. You have in your security agreement or consignment agreement that the consignor or the supplier has authority to just file UCC 1 without the signature. I think that's part one. Part two.
Okay, part two of his question is also, what if that person leaves the corporation and they file bankruptcy? Does that make a difference when you present the PMSI to the bankruptcy court?
Again, that would be the security agreement that's being signed. And the key is, at the time of the signature, that person had authority to bind the debtor customer. And if that person subsequently leaves, that doesn't in any way decrease or cause a demise of the security interest. So that's really not a problem. From an evidence standpoint, getting into evidence, sometimes that can be difficult because I got to prove it up in court, but that doesn't go to the perfection. So the departure doesn't invalidate the security interest in the PMSI.
Okay, Joe. We do not have any more questions at this time. With that, we are going to close today's webinar. I would like to thank Joe Coleman and John Everhart for taking the time to present to our group today, and thank all of today's attendees for taking time out of their day to join us. Thank you all again, and we look forward to seeing you at our next webinar.